Hello, I'm Anavultus, and here with me we have.
Hello, everybody. I'm Wyatt Berckenhoff, are to break down with WB. I'm glad to be here today.
Yes, and today on Getting the Answers we have an interesting historical topic, the trial of King Charles I. Now, as a historical topic, this is actually very significant because it's a bit of a seminal moment in both the history of the United States and of Great Britain, and therefore, by extension, the rest of the world, due to the impacts of those countries in the following centuries. And also, from a very, not just political, but philosophical perspective, it is very important.
Yes, for sure. I don't want to spoil the beans too early in the outcome of why it's so historic, but this is definitely a one in a kind almost event, especially at that time period. I don't think many people in that time period thought something like what happened could have happened.
Yeah. So anyway, to give some background on the trial, why was King Charles the first on trial? Well, it goes back to a number of different events, and you could take the chain of events way back many centuries, but you can essentially say that in the 1600s, England had some problems with religious unity, where there were the Church of England in England, of course, and they had a mixture of high church people that favored the rituals of the Roman Catholic Church in many ways and had sympathies with them. And then there were the low church people, which sometimes aligned very much with the Presbyterians in Scotland. But at the time in the continent, there was a war raging between the Catholics and the Protestants, and that led to a higher tension politically, ideologically, and religiously in this time period in England, where there were questions arising over whether the alignment of the king, where things would go politically in the future. Some people were saying that it was the end times. So there's a lot of different ideas going around relating to the religious tension at the time. And so eventually in this time, England, Scotland, and Ireland were united as separate kingdoms, but under the same ruler by King James, and later on his son, King Charles, who's the topic of discussion today. And in his reign, he based a lot of his philosophy on rulership on that of his father, King James, who had written a number of political works, the True Law of Free Monarchies, the Basilicon Doron, and he was favoring ideas of divine right, which were adopted by King Charles, and also ideas on the responsibilities of rulers and on the subjects of the rulers, and how exactly authority relates to rulership. And those were very important themes in the philosophy of King James. King Charles was also influenced by more continental ideas of absolutism that he saw exercised in France and Spain. And he also had a great interest in art and aesthetics, and funded the arts majorly in many different ways. And religiously, he was a more high church individual, so he favored more the ritualistic aspect of things and more complex ideas on the sacraments. And that led to the more Protestants among his subjects thinking that he may be a crypto Catholic, because they were afraid of the Roman Catholics, and they thought that he might be secretly a Roman Catholic or allied with the Roman Catholics, which at the time, with the military conflicts happening in other countries, that was a major problem. But anyway, as he ruled, he tried to avoid Parliament as much as possible, and he tried to rule as much as possible from his own authority. And because of the way the Kingdom of England was set up, in order to establish taxes, you needed to go through Parliament. So he did some clever workarounds in trying to raise revenue for himself. And ultimately, as things went on in Scotland, he tried to change the organization of the church in Scotland, which led to a lot of resentment by the locals who had preferred their own religious ideas as they had, and were afraid that he was moving them to from a Presbyterian system to a more Episcopalian system, which is what they did not like. And that led to a rebellion in Scotland that went on for a few years and inflamed again over time. And in fighting these rebellions and in paying reparations when he was not successful in some instances, the king ran out of money and he had to convene Parliament in order to raise new taxes. And unfortunately for him, Parliament wasn't very friendly in raising those taxes. So the king ordered certain members of Parliament arrested for resistance against the king and his ideals, which eventually led Parliament, or at least many elements of Parliament, to gather together and to militarize itself. And then the king gathered a military of his own in order to fight Parliament, which led to the English Civil Wars. And there's more than one, but they generally follow a similar timescale and were fought by similar lords for similar reasons. But eventually the king loses both the First and Second English Civil War, which leads him to be a captive of Parliament. And at this point, the House of Commons decides on its own, after purging a number of its members in what's called Pride's Purge, to put the king on trial for treason, high treason specifically, because there's such a thing as petty treason, which is a different crime, and a number of other high crimes and misdemeanors. And that is where the king gets to be on trial. Do you have something to add about this?
Right. If I'm not mistaken, wasn't his wife supposedly Catholic or Catholic? I think there was also some debate over that, if I remember right.
I'm not entirely sure about that, but I do believe that his wife was from a Catholic country at least. So she may have been a practicing Catholic. I'm not sure.
Yeah. I thought I remember reading that somewhere. I'm not 100% sure if that is the case or not. I was just wondering if you knew about that. That was a very comprehensive history lesson there. I don't think I have anything necessarily to add from it, but I do have a question kind of similar to it. So you mentioned that the king thought of, divine rule, meaning that he thought he got his adorship or authority from God or is a god, one of those two things. Do you think that led to him doing, how do I say this? Do you think that led to him doing more, for lack of better words, extreme things than if he thought he was bound to the people?
Well, I do believe that he sort of mixed that idea with a more continental absolutism, because if you actually read The True Law of Free Monarchies by King James, it actually talks about the king having a number of responsibilities to his subjects that, arguably speaking, King Charles wasn't fulfilling. So I wouldn't say that it's necessarily based on that idea alone. I think that there's a lot of influence in wanting to copy ideas used in other countries, because this is the time of Louis XIII and the XIV as well. That period overlaps with this one. So in that sense, he was, of course, basing parts of his ideas on that, because this idea of divine right to rule was also noted in the Basilicon Doron, which is a book that King James wrote originally for his older son Henry, but Henry had died, so it was instead given to Charles. And while it is a book that talks about the responsibility of the king to God and the king to his people and the people to the king and how the king should live his life and how he should rule, it's a book of advice to kings. It does include the idea of divine right in it. So in that sense, it is very important to understand that that is partially where he came from. However, I would say that from having looked at this literature a bit, that it seems to me that King Charles wasn't following the advice to the fullest, because although I can actually read a little bit of the true law of free monarchies, if you like here. I think there's a paragraph that goes into it. And by the way, this is written before James became the King of England, so it was when he was King of Scotland primarily. So it deals with Scottish history a bit, and sort of a bit of a semi-mythological history that was at the time accepted by people. But I think modern historians aren't as entirely sure on that. But following on that mythological history of the founding of Scotland, James says, "The kings, therefore, in Scotland were before any estates or ranks of men within the same, before any parliaments were holden or laws made, and by them was the land distributed, which at the first was whole theirs, states erected and discerned, and forms of government devised and established, and so it follows of necessity that the kings were the authors and makers of the laws, and not the laws of the kings. And to prove this, my assertion more clearly, it is evident by the rolls of our chancellery, which contain our eldest and fundamental laws, that the king is, and these are Latin terms, Dominus omnium bonorum and Dominus directus totius domini, the whole subjects being but his vassals, and from him holding all their lands as their overlord, and according to good services done unto him, changeth their holdings from tack to few, from ward to blanche, erected new baronies, and uniteth old without advice or authority of either parliament or any other subaltern or of lower status judicial seat. So as if wrong might be admitted in play, albeit I grant wrong should be wrong in all persons, the king might have a better colour for his pleasure without further reason to take the land from his lieges as overlord of the whole, and do with it as pleaseth him, since all that they hold is of him. Then, as foolish writers say, the people might unmake the king, and put another in his room. But either of them is unlawful, and against the ordinance of God ought to be alike odious to be thought, much less put in practice." So what King James is saying there, and by the way, this is written in Scots, which is a language a little bit different than English, but similar enough that I can read it. He's saying that in Scotland, all of the land originally belongs to the king, and that therefore anybody else that holds land or property holds it as a vassal of the king and therefore at the pleasure of the king. He's saying that though the king has a responsibility to rule rightly, the king also has the right to control the property of his land and of his vassals. And later on, in a further paragraph, he talks about how if somebody dies without an heir, the property reverts to the king, or if somebody finds a hoard that is something buried somewhere, that it belongs to the king if it doesn't have an owner, and that if a bastard dies, his property goes to the king. So he's essentially saying, beyond the idea of divine right, which is easy to put forward, but he's saying that in Scotland, everything belongs to the king unless it is given by the king to someone else. And that it is unlawful and wrong for the people to undo the king. That is to say, the king cannot be evicted by the people, and also that the authority of the king precedes the law because the king establishes the law. That is his doctrine, and I believe that in large part this was followed by King Charles, although in England the political atmosphere was different because historically you have the Magna Carta and a number of other situations where the king had to negotiate with the barons for his rule. And of course in Scotland, similarly, there were a lot of powerful lords that were able to diminish the king's authority in various situations. But understanding that King Charles had this idea of rulership is very important to understand his conduct in the trial. And right. I think, yeah. So do you have anything to say in relation to that?
No, right. That's a good way to set it up for the trial, because I think it's very important to understand his approach and how he viewed the citizens or how he viewed the law. Because then once you start to see the trial and the way he argued his defense, it makes a lot more sense.
Yeah.
But I did have one more question relating to the history. When he was taking over the armies or taking over the soldiers, let's just put it that way, he was focused more on the Navy, if I'm not mistaken, right?
Well, I think you're referring to how he was gathering revenue. He was gathering revenue right, by embezzling from the Navy, from funds directed towards the Navy. So in that sense, that's before the war started, because the war was at this point. Later on, naval conflicts become more important, but at this point, the war was largely fought on land and in England. So in that sense, the Navy wasn't too important at the time. But what you're talking about is before the war started, one of the ways in which the king gathered revenue was by embezzling funds from the Navy that the Commons and the House of Lords had directed to be given to the Navy, but had instead been taken by the king for his own purposes, because the king did not want to cooperate with the Houses of Parliament in order to gather funds, because in doing so, it would make him inferior to Parliament in his mind. And that is something that he wanted to avoid doing.
Right.
Yeah, so in the following paragraph on the true law of free monarchies, the first sentence goes, "And according to the fundamental laws already alleged, we daily see that in the Parliament, which is nothing else but the head court of the king and his vassals, the laws are but craved by his subjects, and only made by him at their rogation and with their advice. For albeit the king makes daily statutes and ordinances, enjoining such pains thereto as he thinks meet, without any advice of Parliament or estates. Yet it lies in the power of no Parliament to make any kind of law or statute without his scepter be to it, for giving it the force of law. And then he goes on. But that, I think that particular thing about how the force of the king relates to Parliament is, I think, very important in the defense of King Charles, because it colors the defense in a very clearly understandable way. But if we're actually going to let's move on to the trial. Actually, I'm not going to read the whole thing. I think we've both read it. I actually read it a couple years back before, but I'm going to switch over here so everyone can see. Now, this isn't too legible. This is a scan of a book, and it's faded somewhat in certain places, but it's still legible. The book we're using here is A Complete Collection of State Trials and Proceedings for High Treason and Other Crimes and Misdemeanors from the Earliest Period to the Year 1783, with Notes and Other Illustrations, Volume 4. You can get it as a free ebook on Google Books, so anybody can read the trial, not just of King Charles, but of other individuals that were put on trial. This particular volume covers the trials under King Charles I and Charles II. But anyway, an excerpt here that I think fairly discusses the points of the court, and by extension the prosecution, and then the defense, which is the king, is the Lord President says, "If you had been pleased to have observed what was hinted to you by the court at your first coming hither, you would have known by what authority, which authority requires you in the name of the people of England, of which you are elected king, to answer them." To which the king responds, "No, sir, I deny that." And the Lord President says, "If you acknowledge not the authority of a court, they must proceed." To which the king says, "I do tell them so. England was never an elective kingdom, but an hereditary kingdom for near these 1,000 years. Therefore let me know by what authority I am called hither. I do not stand more for the liberty, I do stand more for the liberty of my people than any here that come to be my pretended judges. And therefore let me know by what lawful authority I am seated here, and I will answer it. Otherwise, I will not answer it." So that is essentially the process that the court went through for about 3 days, where the king entered, the Lord President convened the trial, the prosecution made the charges, and then the Lord President asked the king what his plea was, and the king refused to enter a plea, and instead argued that the court which he was facing was an unlawful court by questioning the legitimacy of the court that he was in.
Right, yes. Which is a somewhat of a clever defensive strategy, I think, especially for that time period. But I also want to throw one more thing out there. The trial itself, there was obviously the parliamentarians, the House of Commons, and others who were there to look over the trial and ultimately have votes.
Yeah, a House of Commons that had been purged of of people that weren't interested in putting the king on trial.
Right. Many people did not show up, and many fled.
Yeah.
Over the first few days, yeah. But So taking the strategy the king took, the defense in this case, the defendant, whatever word you want to use, of saying that you have essentially no legal jurisdiction over me. You have no way to prosecute me because I am, the king.
Not just
You have to,
that, he's saying that they have no
right,
legal jurisdiction at all
right.
because they're just the House of Commons by themselves, and they haven't consulted the House of Lords, and not only the House of Commons, but a strongly purged House of Commons that is simply being supported by the parliamentary military and is proceeding without the House of Lords and, of course, without the assent of the king, and is putting the king on trial in a way that has no precedent in English law.
Yeah, because like you just mentioned, they didn't even get like the okay from the House of Lords. In fact, I think they got the opposite of that by the time they did ask, uh, which is not particularly too well. And also, many people of the House of Commons, high-profile people, decided not to show up either. I believe that Lord Fairfax was one, if my memory is right, but his wife was there, which is a
I don't know
funny side story.
what house Lord Fairfax would have been in, but of course, let me be very clear on the trial. While the trial was largely composed of members of the House of Commons, it wasn't just exclusively members of the House of Commons. It was a number of people who were gathered together to be judges in the trial.
Right. I believe he was the army commander, but his party was
Yeah.
moderate, if
Yeah,
I'm not
Lord
mistaken.
Fairfax was the primary parliamentary commander. He was the commander in chief. However, he was someone who was more interested in negotiating with the king and gaining a peaceful settlement rather than putting the king on trial for a crime. Especially when you consider that the standard penalty for treason is to be hung, drawn, and quartered, which at the time would have been something very horrible to do to a king. And therefore, it is a very undignified way of dying because it's a strong humiliation. Now, of course, his second in command, the famous Oliver Cromwell, was in favor of putting the king on trial and ended up even stating that he would have the king executed, which is something that a lot of people were uncomfortable with. He himself included to some respect. As far as I have heard, he prayed a lot. He wasn't entirely 100% sure whether he was doing the right thing. And the same is true for a lot of the people involved. It wasn't that they wanted to have the king be convicted of treason and be put to death. A lot of them were very unsure about what they were doing. They were very unsure as to whether what they were doing was right or whether there would have been a better alternative. Some of them thought that they were looking at an eschatological event, that the time they were living in was going to be very close to the end of the world, and they had that mindset, some of them did. And of course, many people who had been approached with running the trial as the Lord President of the High Court of Justice had refused for various reasons, because they were unsure about the trial, they were unsure about what they should do, and it was a big problem because they were also afraid of retaliation in case that ultimately the parliamentarians came out of power and then a new king arose, or the king had been restored and he could put them to death for treason, which was a
Right.
problem. Additionally, the idea of putting a king on trial for treason was very weird because traditionally treason had been considered an attack against the king, but he was the king, so unless he had tried to commit suicide or something,
Just
treason,
like, yeah.
treason wouldn't really make sense as a charge. So they had to redefine treason, and they extended the idea of an attack of the king to be an attack on the government, and an attack on the country, and an attack on the people of the country. So it essentially extended that legal doctrine. And they also had to overcome the idea of sovereign immunity, which is the idea that the leader of a country, by virtue of being in charge of a country, can't be charged with a crime without his permission. Especially because, legally speaking, the way courts were established in England at the time, you required the king's permission. So essentially, they were a court that had established itself through its own authority and for military strength, completely ignoring legal precedent and the established statutes of the country, and completely ignoring the previously established legal doctrines that would be relevant in the situation. And that put them into a situation where they essentially were treading new ground, legally speaking. And while some people from later generations viewed this as a positive outcome, there were very many people that viewed this as a negative outcome.
Right, for sure. I think with the whole Bradshaw being the head judge, and like you previously mentioned, they had to look for a judge. It wasn't like they had, people willing to do it necessarily. He seemed willing to, at least from the one video I watched and a couple of articles I read, which makes me almost think that even the judge himself, who's presiding over the court, already had a bias towards the defendant. And that's kind of an interesting thing for me to think about as well.
A bias against the defendant, you mean?
Against the defendant, yes, against the king. Because especially nowadays with how the U.S. court system works, and yes, the U.S. court system's different than what it was in Britain at that time. Yes, I know that, but just putting it into an example, if you have a biased judge, that's a way where you can call mistrial and have another trial with a different judge. Excuse me. So that's almost a interesting point as well to think about on if Bradshaw, the person presiding over the court, had a bias, because it appears to me that he probably did.
Yeah. And so by any means, regardless of whether you agree with the way that new legal doctrines emerged during the trial, I think it is fair to say that the trial itself was a very unfair trial, because it was established specifically by people that were opposed to the king, and specifically purged people who were more neutral or in favor of the king. So in that sense, that was a problematic issue here, where by current standards would certainly not be considered a fair trial. But I think another thing to note is, therefore, what the king is doing when he is refusing to plead. Because when somebody refuses to plead in a trial in those days, it was customary to press the defendant into entering a plea. And by pressing, I mean literally putting weights on the defendant. And I think there's a famous example in the Salem witch trials where there was a man who was pressed to death because he refused to enter a plea, which is interesting, and it happened in a sort of similar time period, so it's operating under similar legal principles. And however, they refused to press the king, as that would have been seen as something very disrespectful and sacrilegious to the people. Because even though the king was on trial and the people that were trying him were legally opposed to the king, still a lot of the common people in the country, and of course the lords, were in support of the king, and even among the members of the House of Commons and of the military that were opposed to the king, many of them still sought to respect the position of the king, even though they were putting the king on trial. So by not pressing the king, I think the court showed a bit of weakness because they were not confident that they could go through with something that would ordinarily happen. But it also could show that they were aware of the legitimacy of the king's argument against the court.
Right, for sure. That's a good point you bring up, and because in a couple of articles I read, it was talking about the point here where ultimately they would torture. You used the example of pressing. There's probably several other methods they could have used to make the defendant plead. Now you bring up a couple of good examples, but my mind immediately went to public perception. Because it seemed to me, with articles I've read and the videos and whatnot over the history of this, it seemed like the public in general was in support of the king. At least the public that were in the trial, at least. Maybe not the whole public, because they were in Civil War. Several Civil Wars. But it seemed to me like the perception at that time was with the king. So I think that they knew by taking the risk of torturing that it could lead to the public perception getting larger, and if they lose the public, then they probably are going to lose the trial.
Yes.
Even if the public sways a little bit towards the king's favor, they can't have it sway so much to where if they do have a verdict of execution or of prison or whatever it may be, the public will retaliate. There's a lot of that going on as well.
Yes. Now, of course, what happened in the trial eventually is that the king did end up being held in contempt of court, and that meant that they could try the king in absentia, that is, without him present, and make a verdict and hear evidence without him present. And this was, of course, a risk from the very beginning that the king undertook. And some people argue that the king's argumentation was very arrogant. And while I agree that the king's argumentation is logically sound, I can see where people come from with the arrogant side of things, because it was as people say, a kangaroo court. It was a court that was aligned against him, and he antagonized the Lord President and other members of the court in the way that he spoke, which led to them eventually holding him in contempt of court. It could be argued that this was an unavoidable outcome because they were intent on finding him guilty regardless of what he was going to say and regardless of what kind of evidence he would bring. And so the purpose of the trial was simply to present the case of the parliamentarians as to why they were deposing the king and were opposed to the king, and justifying their side in the war when the king took up arms and ordered his troops to attack, and then invited troops from Scotland to attack into England, which is what they considered a point of treason, according to the court. So in that sense, because the trial was unfair, when the king spoke strongly in opposition of the court, it essentially became inevitable that he would be held in contempt.
Do you think, you said that you thought the king knew that that was eventually going to happen.
Well, I don't know if the king knew that it was going to happen. It could be possible that the king genuinely thought that the people would still support him and that he could persuade the other side. You could say it's somewhat similar to sovereign citizens in how they behave, where they think that their argument is sound and that people will believe them because of the soundness of an argument that they're putting. Spoiler alert, many times the argument isn't sound in the case of sovereign citizens. But in the case,
99.9.
yeah, and even if it were sound, the fact that the police and the courts are aligned against you isn't going to help you, especially if you then insult the authority of a court. But in the case of King Charles, I think his arguments were sound, at least as it refers to the letter of the law. And however, he simply didn't have a chance. And maybe if he had been more friendly to the court, I'm not saying that he should have sacrificed his argument, but if he had been more friendly to the court, perhaps he would have gotten a lighter sentence.
Do think it's noted for those that don't know the exact details of the trial that he was warned several times before getting the contempt of court. So it wasn't like he said one thing over the judge and the judge was like, okay, you're in contempt of court. It wasn't exactly that fast. But I agree with you that I do think it was probably most likely to happen because really all they wanted to do was sentence the judge, at least the majority of the people that had the power, so to speak. Now, I believe the first vote was, I think it was a slight majority, but it wasn't like a huge amount of people wanting to go forward with the sentence of execution.
Well, actually, as I understand it, they didn't have enough people voting in favor.
It was slightly lower.
Even among the court of the pruned people, where they had already removed the loyalists and everyone.
Right.
They didn't have enough people that were interested in actually following through on a guilty verdict. So Oliver Cromwell and others tried to persuade people, threaten people into voting guilty, and eventually they had just enough people in order to make the verdict seem legitimate, and that is, of course, after a lot of evidence had been presented to the court without the presence of the king, and so they called the king in again, and they sentenced him to death, and he was beheaded, which at the time was considered the honorable method of execution, as opposed to hanging, which was considered dishonorable. And in those days, people wore fancy clothing when they were being beheaded, and they would, in addition to the clothing that they were wearing, give gifts to the executioner to ensure a clean death. And of course, King Charles did receive an execution with one stroke. So in that sense, he died swiftly. I've heard cases where it took multiple strokes.
That's terrible.
Yeah. Good thing that the guillotine was invented. I think that certainly helped a lot of people on death row in those days. But nevertheless, he did die. And to the rest of Europe, this was actually a very horrifying event, because it was a people had killed their own king. It was something that was unconscionable to a lot of people in various other countries, and it sort of set a precedent as well in the minds of people and how they would deal with monarchies.
Right. Well, just one quick note going back to the trial. When the king was taken for contempt of court, was there anyone allowed to be in the king's place? Because from my understanding, it was basically just empty. There was no defense person representing the king.
Yeah, it was empty. In that
It
case,
wasn't.
it would simply just be based on the judgment of the judges, the jury there. They would have to decide based on the evidence that the prosecution presented whether the king was guilty or not.
Right. Okay. That makes a lot more sense because I was trying to look for an answer to that, but it seemed like it was empty, but I wasn't 100% sure. But that makes a lot more sense as well because as you basically mentioned already, there was a ton of witnesses that the prosecutors, the side against the king, called to confirm the acts that the king did, and we already know the verdict of it. But when you're talking about the outcome of it, I mean, it just seems like if you're a king of another country, right? Say France or say a surrounding area, I don't necessarily think that you would be the most happy with this verdict.
Yeah, it was something that was a very scary idea of the king being killed by his people. And of course, it did eventually happen in France as well. And it happened in Mexico. It happened in a number of different countries. So it was a very scary prospect. And it also established the idea of popular sovereignty in England, the idea that the people are sovereign over their rulers, which became very important later on in the United States. So we see the philosophers in England after the events of the English Civil Wars taking a number of different directions, where, of course, the succeeding kings and the restoration of a monarchy had continued to be very absolutist, and perhaps even more so than King Charles had been, because they were in some ways afraid of the people, and they were very interested in preventing what had happened from happening again. And then you see the Glorious Revolution happen later, where King William, with his wife Queen Mary, when they come into the kingship, they actually give more power to the parliament, and we see the birth of the more parliamentarian system that we see today in Britain. That starts developing in that time period when concessions are made to Parliament, and Parliament gains a lot more power in that time. Additionally, you have people like John Locke, very famous, who is in favor of this idea of popular sovereignty to some extent, and he becomes known as the father of liberalism, and not what people today call liberalism, but liberalism in the idea of freedom as a virtue, and that becomes very influential to America's founding fathers. And then you have the opposing idea of Thomas Hobbes, who has this idea of the Leviathan. He was very horrified by the events of the trial of King Charles and his execution. So while he agrees with the idea of a social contract, he also views, by necessity, government being formed as an absolute authority, and that going against the authority is a bad thing in his philosophy. So he's in some ways reacting to that position. And of course, following the death of King Charles, you get the Commonwealth period of England, and eventually the Protectorate. In this time period, the religious reforms favored by the Low Church Anglicans are eventually implemented, and it even comes to the point where they try to convert the Church of England into a Presbyterian system. And so at the time, and of course that eventually gets reversed, but at the time of the American Revolution, there's people in England referring to it as a Presbyterian rebellion, referring to the American Revolution as that. And in some ways, that's calling back to the English Civil War and to the more Republican character of the parliamentarians in the English Civil War with the founding fathers of the United States, and also partially the religious background of some of the founding fathers, although in that sense there's also Unitarians and atheists mixed into there. And it's a more mixed group that end up with a more compromise on what they want religiously, as opposed to the hardcore Puritans at the time of the English Civil War.
That makes a lot of sense, because if you think about it, it's either going to go one of two ways, really, and you kind of described it with the philosophers, right? Of John Locke and Thomas Hobbes, was it again?
Yeah.
Yeah. So you kind of described it with them, but you would think it's either you're going to become more free, for lack of the better words, or it's going to become more strict. And the fact that you can't do this, you know, you that was totally wrong. Or it's going to be like, okay, we know that you now have more power. We'll give you a little bit more, or at least let you think that you have more power, and do it that approach.
Yeah.
But so it would have to go one of the two ways. So it's interesting that even at that time, people were thinking about it from a more law perspective, philosophy perspective, that type of thought process.
Yeah, so the deposition of the king and the idea of popular sovereignty are very important in the concept of the natural law of, not the natural law, the organic law of the United States. That is the basic founding laws of the United States, where you have the Declaration of Independence and the U.S. Constitution. The phrase "we the people" as a constitutive phrase of government, that is, we the people are going to accomplish the government, we the people are forming the government. That idea can be linked back to the idea of the people of England holding the king accountable for his actions, rather than the king being accountable only to God, although still responsible to the people, according to the writings of King James anyway. So that's a shift in accountability and a shift in the focus of the constitutive element of government, whereas under the philosophy of King James, the country as a whole and the government was formed through the actions of the kings. Meanwhile, under the ideas of Thomas Jefferson, the country is formed through the actions of the people.
The idea of popular sovereignty as well, which what you're talking a little about too. Not I had a question, but it just left my brain. I guess I'll ask this. So when you have the concept of popular sovereignty, you have the trial happening, although the trial was biased in a lot of ways, and we know the outcome of execution, so on and so on. After that is all finished, do you think that in England or the United Kingdom, that the perception of how they viewed the king changed? Because I know with Charles II, there was a lot of you could call it, what's the word? Getting back at them. He arrested a lot of the people that voted the wrong way, and it still seemed like he was very authoritative as the next king. but I'm not completely certain if the perception even changed, really.
I think it did change. It certainly did. And it changed in two different ways. In one way, there were the people that viewed this as inspirational and as something that was very transformative or revelatory about kingship and the government. So that is people like John Locke, although I don't think John Locke would be in favor of having an unfair trial in this type of idea. But people like John Locke and Thomas Jefferson, Thomas Paine, that follow that idea that the court put forward and move forward with that. And people like the Covenanters and other groups, people that believe that government is contractual and a covenant between the ruler and the people rather than something rather than the ruler's prerogative. They view this as in some ways as a triumph, and those people certainly did exist. However, at the same time, there's people that were horrified at the event, people that saw this a great injustice, as something that was against the core, the moral core of the country, something that was very bad. And those people who sided with the king, essentially, the you could call them loyalists, you could call them absolutists, you could call them a number of different things. Those people were, of course, strongly opposed to that. And as I said before, these factions reemerge in future generations, just as they themselves are products of the factions of past generations. So we see this again in the Glorious Revolution, where you have people that are very supportive of the king, of King James II at the time, and then the people that invited King William to invade the country. Although they're definitely not as hardcore as the parliamentarians, the so-called Roundheads, were in the days of the English Civil Wars. And of course, later on, once again, the Loyalists and the Patriots in the Revolution and the colonies. So I think it's important for people to understand that regardless of how you think the trial went, regardless of which side you support, regardless as to whether you think that, let's say, the legal doctrines were good but the trial was bad, or vice versa, or whatever comes out of this, that all of these events are connected. And because these events are connected, major events that happen, such as the trial and execution of the ruler of the country, are very important to the formation of a philosophy surrounding these events, to the political outcome of that, and also to the religious outcome that happened afterwards as well.
That's like a lot of history. I don't necessarily think that history goes just one way all the time. There's always a little bit of black and gray with history in the perspective that people have. So it makes sense that there would be mixed for an event like this as well. You kind of already answered that next question, so I don't really have any questions I can think of right now in relation. I don't know if you have any questions or something you wanted to mention as well.
Well, there are people nowadays that have this romanticized image of King Charles as a sort of martyr in that sense. And then there's the people that have the image of him as a tyrant. So the way you view him certainly does have a huge diversity. And of course, the impacts of this event are seen even today, where the impact is seen in British law and American law, and by extension, the legal systems that followed them in a number of different ways, that has a huge impact in the world, on all continents, and therefore it is always important as an element of study.
Right. Big fan of history, and I used to study history a lot. I need to probably get more into studying history, especially history that I don't know too much. And this time period, I don't know a whole bunch about. But that's why I found this topic really interesting. But on a side note to that, I do think it's very important that history, legal history, or just history in general, is studied to know where to. Well, one thing that is a common stereotype, history is going to repeat itself, blah, blah, blah. I don't think we're going to be executing anybody nowadays, but I think it's still important to know the way a trial was done to either keep some parts or not keep parts. It's history is big on that. So I'm a big fan of studying history for that one point, and then studying history to know, uh, what happened in the past and take good things away and know not to do other things.
Yeah. Yeah, and I suppose a recent question relating to this was it okay for people to enter the capital? And I think that's more connected to the trial of King Charles than a lot of people may realize.
Sophie Fest,
Yeah.
as Ed calls it. Yeah, that's a question I would have to think about. I kind of already have a stance on that question, really. But long story short, I'm not really sure if I would have called it a insurrection or not. I don't know. I think you have a slightly different opinion on that from when we had our first conversation on it, and from when I've heard you talk to Steven about it on one of his shows.
Yeah. But anyway, I think that we have covered the topic well enough. If people have any questions, feel free to ask us, or even better, read the source material. You can read a full transcript of a trial free, for free. You can download an ebook. So no excuse not to know something about the trial. If you're going to ask us a question about something that happened in the trial, just read it for yourself.
Anavultus is calling them out.
Yeah.
Yeah, it is slightly hard to read, but definitely all of it is there. So it's not like it takes hours to read, and it take that long. So it's an interesting read, especially if you're a history fan. So
Yeah. So anyway, I think that we can conclude here. Do you have anything more to say?
no, I don't have anything more to say. All the questions I had were answered, and we hit all the points that I had. So I'm good on me.
Okay. So thank you all for watching, our beautiful audience, and we will be seeing you next time on his channel. So feel free to look that up, just like the last episode was also on his channel. And the episode after the next one will be on my channel once more. So thank you all for watching, and we'll be seeing you all next time on Anavultus over and out.